5 seconds to go. Start. The second appeal preferred by the parties, that is RSA number 236 of 1999, was dismissed on 16th June 2005. The High Court pertinently observed and held that the appellants herein were in possession of the suit schedule property and rightly injuncted the respondents from interfering with their peaceful possession and enjoyment of the same, holding further that there was deemed cancellation of the grant of land granted in favor of the respondents herein as due procedure had not been followed. These findings were challenged in a suit filed by the appellants, which claimed that they had absolute title to the property. No doubt, KIC's suit claimed injunction, its dismissal, if that were the only proceeding, would not have precluded a subsequent suit claiming title. However, the fact here is that KIC was a respondent in the suit filed by the appellant, that is, the 1995 suit, which expressly sought the relief of declaration that the appellant was the absolute owner. It was in such a context that the question of ownership, which was directly in issue in a proceeding, that is, a suit filed before a competent court, was decided. That decision ruled out KIC's ownership, holding that there was deemed cancellation of the grant of land before the High Court. All these facts were disclosed by KIC in the suit filed after this court dismissed its civil appeal, thus rendering the judgment in the second appeal final. In these circumstances, the issue which remains is whether the trial court wrongly rejected KIC suit second as found by the impugned judgment. In Anathula Sudhakar, this court outlined various situations in which a person claiming possession or injunction can claim relief. They are set out below. To summarize, the position in regard to suits for prohibitory injunction relating to immovable property is as under: where a cloud is raised over the plaintiff's title and he does not have possession, a suit for declaration and possession with or without a consequential injunction is the remedy. Where the plaintiff's title is not in dispute or under a cloud, but he is out of possession, he has to sue for possession with a consequential injunction. Where there is merely an interference with the plaintiff's lawful possession or threat of dispossession, it is sufficient to sue for an injunction simpliciter. As a suit for injunction simpliciter is concerned only with possession, normally the issue of title will not be directly and substantially in issue. The prayer for injunction will be decided with reference to the finding on possession, but in cases where de jure possession has to be established on the basis of title to the property, as in the case of vacant sites, the issue of title may directly and substantially arise for consideration, as without a finding thereon, it will not be possible to decide the issue of possession. Stop.